We talked about the general time frame of how long it takes, how long a patient has. What happens, though, if the wrongdoing happened in a municipal hospital? Jacobi Hospital, Elmhurst Hospital, Queens General Hospital, Harlem Hospital. Anybody know how much time an injured patient has to bring a lawsuit? The answer is 90 days from the date of the wrongdoing to file a notice of claim to put the municipality on notice, and the patient has only 1 year and 90 days within which to file suit. And by the way, that filing of the notice of claim is a prerequisite, it's a requirement that must be done before. If the patient comes to you now, it's after 90 days, they can still try and ask the court for permission to file a late claim, but doing that is a very long and involved process, and you're not always successful. It involves getting all the records and having an expert review it and support the argument. And then you have to explain to the court why the patient delayed bringing this within 90 days or filing a notice of claim. All right, what happens, though, in a situation involving an improperly performed delivery resulting in damage to a baby? How much time does the family, do the parents have in which to file suit on behalf of the baby in a private hospital and for a private doctor? Anybody know? In New York, you have 10 years from the date of birth within which to file suit. So now let's jump ahead to what happens if this happened in a municipal hospital. There was an improper delivery. How much time does the family have? They don't have 10 years. They don't have 2.5 years. They have to file a notice of claim within 90 days from the date of the wrongdoing. And then they have 1 year and 90 days in which to file suit. Big, big difference. Huge difference. So, what's the next one I want to talk about? What happens if a family member dies and now the surviving family wants to sue? How much time does the family have to bring suit for medical malpractice and wrongful death? The answer is 2 years from the date of death. So you notice we started off with a general rule of 2.5 years, and now there are many different variations. Okay, so that's 2 years against a private hospital and private doctor. Now let's turn it around. What happens if this is a municipal hospital? How much time do the surviving family members have to bring suit against the municipality? Shout it out. You know the answer. 90 days to file a notice of claim, 1 year and 90 days in which to file suit. Very, very different. So make sure when somebody is telling you their story, their tale of woe about what happened to them, you identify exactly where this occurred. And that's part of the questions I'm going to get to shortly about giving you those tips about the 4 questions you need to ask, almost like in Passover, about the 4 questions you need to know. All right. Now, anybody hear about something called continuous treatment? Well, continuous treatment is a doctrine that says a patient who continues to treat with their doctor, the time in which they have to bring a lawsuit may be extended until the time that there's no longer a doctor-patient relationship. And why does the court allow this? Because they want the patient to continue getting the treatment from their ongoing doctor, somebody who they're caring for. The doctor presumably knows the patient's condition and is in the best position to try and help them. So they don't want the patient interrupting their care until they realize there's nothing more the doctor can do, at which point the clock starts to run. But here's an interesting situation. Let's say the patient goes to the doctor making certain complaints, and then over the course of time, the patient continues to see the doctor, but for other issues unrelated to the original problem they went there for. Does the patient get the benefit of continuous treatment? You shake your head no. You would be right. Okay? And I'll give you a great example. And this involves a dental scenario, dental case. A patient goes in complaining of a problem in the upper left molar. And over the next couple of weeks and months and years, the patient has lots of other dental treatment. Now, 3 years down the road, the patient has significant problem in the upper left molar and now needs all sorts of surgery and other problems, and the patient wants to sue the doctor. The problem is, did this patient have continuous treatment? And I will tell you, in all honesty, When you talk to somebody and now this issue arises about gaps in treatment, or the patient goes for treatment for other things, you are not going to be able to know for certain whether or not there is the benefit of continuous treatment. Why? Because in order to really know the answer of whether the patient can get this benefit of extending the time to bring a case, we have to scour the patient's entire record page by page, visit by visit. We need to know why the patient returned back to the doctor. What was the intention? Why did the patient come back? Was it at the doctor's urging, or did the patient have a complaint now, an emergency? These make a big difference about whether there's continuous treatment and an ongoing relationship. And the key to answer in these questions about whether or not you can get continuous treatment is, did the patient continue to receive treatment from the doctor for the same condition and same complaint that they originally went to them for? If the answer is yes, they'll get continuous treatment. Now their case will be timely. If the answer is no, and you have a gap, a significant gap of treatment, guess what? Then the answer is no.